Speaker.
Resuming debate, the Honourable Member for Parkdale-High Park.
Thank you, Mr. Speaker, and I'm pleased to speak on Bill C-43, an act to amend the Immigration and Refugee Protection Act, and I want to thank my colleague from Algoma, Manitoulin-Kapuskasing, who just spoke, and I could feel how passionate she is about this issue. I also want to thank the Honourable Member from Newton North Delta, who has played such an important role in this House on immigration and refugee issues, and I thank her for her fine work on that. Mr. Speaker, this bill is one that addresses an issue about people who come to Canada and commit crimes, and it's interesting, the timing of this bill, because it is coming on the heels of some very serious, difficult and controversial changes in immigration and refugee policy that have touched many members of my own community in Parkdale-High Park. And I'm speaking specifically about the Refugee Reform Bill, C-31, and also cuts to refugee health care. In my community, part of my community, it's a place where many newcomers first come to Canada, and we've seen waves of refugees come from different parts of the world. There are many religious institutions and places of worship that are amongst the oldest in the city of Toronto, because they are the first stopping off point for many newcomers to Canada. So we have the oldest continuously functioning Jewish shul. We have one of the oldest Hindu temples. We have religious institutions of various denominations. And more recently, we have many refugees coming from places like Tibet and Hungary and other places in Eastern Europe. And something that has been very controversial in our community, and we have joined with health professionals in opposing, were the changes to deny some refugees or refugee claimants health care benefits. I have seen firsthand in my community people who are directly affected by these changes, and it has not been helpful that certain communities, such as the Roma community, have been demonized by this government, and it creates a situation that is unhealthy for them here, even prior to the status of their refugee claim being assessed. So it is interesting that now the Conservatives are introducing a bill to get immigration discussion back into a territory that they feel more comfortable with, and that is a tough-on-crime approach. And so I see that in the political context of dealing with refugee and immigration issues. This bill would give more power, would concentrate more power in the hands of the minister in terms of discretionary authority over the admissibility of temporary residents, and he can declare a foreign national inadmissible for up to 36 months if in his or her opinion it's justified by public policy considerations. The bill also relieves the minister of the responsibility to consider humanitarian considerations, compassionate situations, such as taking into consideration the interests of a child. So the minister no longer has to consider humanitarian concerns at all. It also gives the minister new discretionary authority to provide an exemption to the family member of a foreign national that is, quote-unquote, inadmissible if he or she believes it is against the national interest, specifically examining national security or public safety. There are also changes in this bill about what constitutes serious criminality, and previously a conviction in Canada resulting in a prison sentence of 2 years or more constitute an automatic revocation of a permanent or temporary resident's right to an appeal. This would revoke that right with a conviction of 6 months or more, which has to really be explored and investigated what kind of crimes we're looking at here and who is more likely to be affected. It increases the penalties for misrepresentation, taking them from 2 years to 5 years for inadmissibility for permanent resident status. And one thing that I think is very positive in this bill, it clarifies that if someone enters Canada as part of an organized criminal activity, that on its own would not constitute inadmissibility, which may be important to people who are trafficked into Canada through some kind of criminal organization. So while there is a legitimate concern, and I believe Canadians are legitimately concerned about the issue of non-citizens who commit serious crimes in Canada, we have a concern about concentrating more arbitrary powers in the hands of the minister. The vast majority of newcomers to Canada, and again, I see many, many of them in my community with direct experience, they're law-abiding people, they don't commit crimes, and we believe that the Conservatives ought to spend more time and more effort making sure that these people are treated fairly and quickly and are reunited with their families as quickly as possible. And Conservatives can have it both ways. You can't take someone like Conrad Black and welcome him back to Canada with open arms and claim, as the minister did, that this was independent of politics and handled by bureaucrats, and then introduce a law like this, which clearly is concentrating more discretion and power, discretionary decision-making power in the hands of the minister. Suddenly, he seems to have a conversion on the road to Damascus and wants to deport convicted criminals instead of welcoming them with open arms. So that's quite a change. But I do believe that there are a number of other ways the minister could help, such as maybe no longer appointing his friends to the Immigration and Refugee Board and having a fair process there. So while, yes, the issue of criminal activity and making sure we're not getting the wrong people here in Canada is important, we believe that there are concerns that are not being taken into account. Mental health issues are a big area of concern. I know in my community and in communities across the country, there are people who come here as refugees from war-torn countries. They do not get the kind of mental health support that they need, and we all know that there is a disproportionate representation of people who are mental health survivors in the prison system who desperately need help and would benefit greatly from help here in Canada, including many refugees, and whom deportation will not help. And I think Canada will see people from war-torn countries who are disproportionately rejected from Canada under this bill. So mental health is clearly a huge issue, and also the lack of ability to appeal. And that, of course, is up to the discretion of the minister, but the lack of appeal is something that has been criticized in other immigration initiatives by this government, and is certainly one that I would question here. I see my time is almost up, Mr. Speaker, but I want to say, while of course we support the issue of making sure that Canadians are protected from criminals who would take advantage of our immigration and refugee system and come to this country and commit crimes, that there are problems with this bill. It needs serious discussion, serious investigation, and serious changes in order to do the job that it is meant to do. With that, thank you, Mr. Speaker.
My colleague was talking about concerns with increasing the ministerial discretion
And I think it raises an interesting point. I'm sure my friend is aware that in 2011, the Quebec Assembly passed a unanimous motion asking the minister to stop 2 individuals from coming to Canada due to their comments encouraging hate and violence against women and homosexuals. Unfortunately, there was no ability for the minister to stop those people from coming into the country. This bill will address that issue. So I have a couple of questions. Does the member and the NDP agree or disagree with Quebecers in the Quebec Assembly? Do they think that people who promote hate and violence should be allowed into Canada? And if they don't think that they should be coming into Canada, why won't they stand and support this legislation which will give the minister the power to do exactly that?
The honourable member for Parkdale-High Park.
Well, I thank the member for his question, and I haven't read the bill in question because it's not a bill that's been before this House. Obviously, as champions of human rights and working constantly against anti-racism and anti-sexist behavior, we support those goals. What is a concern is concentrating discretionary power in the hands of the minister through this bill, and also casting a net so wide that it has unintended consequences. Let me just give you one more example quickly. Suppose someone comes to this country as an infant, the child of immigrants or refugees, grows up in this country, spends their life here, and as an adult commits a crime, but has never taken out Canadian citizenship. That person could potentially be sent back to a country where they have no connection, no family, no relationship to, because they've served a sentence of 6 months in a Canadian jail seems extreme. So I would question the broad net of this bill.
Questions and comments? The honourable member for Winnipeg North.
Yes, thank you, Mr. Speaker. I think that most people on whole recognize that there is a difference in the types of crimes that are committed. And this goes to the member's response to the last question, and that is in regards to crimes that will ultimately lead to a conviction that would have a person have 6 months or more. Now, when we talk 6 months, we're not just talking of jail time. That could be part of conditional sentences and so forth. It's just a summary conviction that ultimately leads to a minimum of six months. We just passed legislation not that long ago that would say that if you're caught with 6 plants of marijuana, that means you go to jail for 6 months. In that particular application, that would mean that if a person was here for many years, as she's pointed out, 10, 15 years plus, even if they have a family, that one individual could actually be deported because they happen to have had 6 plants of marijuana. Now, it's not a rapist or a murderer or something of this nature, but yes, it is a violation because the law says you can't have 6 plants. I'm wondering if she can maybe provide comment in terms of, does she see that as justice being served in that sort of a situation?
The honourable member for Parkdale-High Park.
Well, I thank the member for that question, and it is in keeping with what I've been describing here, is that reducing the rule from 2 years to 6 months could capture far too many people in this wide net who someone might be a first-time offender, someone who's lived here all their lives, someone who maybe has a mental illness, or someone who just made a terrible mistake and who would benefit from rehabilitation, would benefit from perhaps other opportunities, could then become a productive and positive member of Canada, but because of one stupid mistake, and my colleague has indicated, a crime of growing some marijuana plants could land them in this situation. It seems overly harsh and overly discretionary to have this kind of consequence for that crime.
Resuming debate, the honourable member for St. John's East.
Thank you, Mr. Speaker. And I am